for you as an animal owner is, did the horse get out because the landlord left the gate open? Then you might have a different story. But generally, if someone is boarding off of you, they go out trail riding on somebody else's property, something happens, you're in the clear. Transfer of ownership is one that comes up a lot with me. You're not going to have liability towards a potential future plaintiff if you notify the new owner that yes, this dog bites every posting. Get it in writing when you handle the bill of sale, that they had knowledge that whatever this animal does, you're giving them knowledge of that. Then that's a defense. You say, well, I informed the new owner. They're now the keeper and the harborer of the animal. It's their responsibility.
I apologize if you covered this, and I was a little late. I have a neighbor who has a horse boarding business, and I have 65 acres next to them. And sometimes there are people come up and ride around with me and go back. We never really discussed it, but I acquiesced to it because I never told them not to. So does that, and what if your horse gets stung in the ass and someone wipes out and gets hurt out in my field?
Yeah, you might have a problem.
So I should approach them to get
You need a contract, my man.
a contract?
Yep. And you know what you need to do? You don't want to charge for it.
No.
And you'll see why in a minute. I'll cover that.
I had an insurance agent told me that I should ask them to put me on their liability insurance.
Not a bad idea either. It's called an additional insured.
Yeah.
Okay, it's going to cover that, I'm sure.
Okay.
Always try to be an additional insured. It's a great thing.
We back up once.
Sure, go ahead.
Because you just touched on it. The assumption of risk laws that are already in New York, I would contend, he has no worries whatsoever, other than the fact you'll find a lawyer somewhere that'll say, yeah, I'll take your case, we'll spin a yarn, and we'll sue, and they'll end up getting all kinds of grief over it, but I would contend they probably won't win anything. There's assumption of risk every time you go out. Snowmobilers, skiers, I don't care what it is.
And generally what we find, I'll touch on it now, it's not in here. I think I talked about this the last time I did. If you're on somebody else's property and it's just woods you're riding in, and it's in its natural state, you're probably not going to have liability if that person falls off and whacks their head on a rock. The rock's just there as a matter of nature. If they're riding on your property and you're out putting in a well and you got a pipe sticking out of the ground, they fall off and cut their head on that pipe, that's when you're going to be in a problem. But just in the natural state of things, you probably don't have to worry. You may be shotgunned into it, but you can probably get out of it. You know, there's always shotgun litigation. I've been guilty of it myself. You know, sometimes as lawyers, you know, we don't know what the contractual relationship might be between you and your neighbor prior to the lawsuit. So if we don't have knowledge of that contract, we might assume that there is one, and you both might have insurance to cover that. And you know, usually I'm pretty good if I have a plaintiff's case. If I shotgun something and you know, there's no contractual agreement there or anything that's going to help me, you know, I'm going to let the one person out. Some people, you know, they'll go for the wall, but I like to focus on where the insurance money is.
Oh, so you're assuming.
I do both plaintiff and defense work.
All right.
More plaintiffs work now, but.
Long as we're on that subject, the
Go ahead.
assumption of risk,
Go ahead.
the Trial Lawyers Association
Go
for years has been lobbying against
Sure.
the inherent risk law, the equine inherent risk law in New York State, which would be similar to the inherent risk law they have, I think, for ski centers now. So why are they lobbying so hard against an inherent risk law?
Well, they have their reasons.
What?
They have their reasons.
You don't know what they are, or you don't want to tell us?
Well,
I've heard Farm Bureau's version of what their reasons are.
yeah. Money.
Another spin,
Yeah.
another spin.
I think what you're going to see with the similarity to the ski center, I don't think we're going to get anything legislative on that in the near future. There's certainly nothing coming down the pipe this year that I'm aware of.
Not this year. Well, the Farm Bureau just notified us that after how many years, I couldn't tell you, they finally got the Trial Lawyers Association to sit down with them to try to work out the differences. But there's an inherent risk law in I don't know how many states. It must be 18, 20 states.
Yep, I think more than that.
And
I think 28.
their insurance costs are a lot less than ours because.
Yep. I think just the way I see things going, the way I read some of these cases, I think judicially, might be pushing towards that, but, without that statute in place, it's tough. I'm trying to think the last time it tried to go through. I think it was three years ago, maybe?
Well, it keeps getting nailed in committees.
Yeah.
Every year they try.
Yeah, most things never go very far. I don't think it's on the docket this year. I know we just had the legislative meeting for the State Animal Law Committee, and I don't remember anybody mentioning it, but
Not this year.
there are quite a few bills out there. But it's, how last year we just tried to move the cruelty to animals from the agricultural markets law into the penal law, which would make logical sense, and that went nowhere. So it's tough to move even the smallest things. Onto that, landowner's liability. As a landowner, a lessee, or occupant, if you're using undeveloped land, you're going to have those protections. If it's just a natural formation that someone injures themselves on, you're probably not going to be held liable.
Or ag fields, like farms, like hay fields.
Right. Yeah, same thing. But if, again, if you have the hay rake out there, whether or not that's going to be, but, just an example. The key really with the waiver and the assumed risk, you want to make sure you're not being compensated for the use. If someone signs a waiver and they're paying you to use the land, you can't have it both ways. You can't get the money and have the liability protection. That's just a public policy rule in New York State. So if you're just letting somebody, your neighbor or somebody do something, don't charge. Just get the waiver, get the contract. Yeah.
How is that then? Because one of the problems that we have in the various parts of the state where we do ride across other people's lands, they won't let us because if I fall off my horse, doesn't matter whether I was stupid, didn't duck because I went under a tree and it was my fault, I can sue them and this is they're not, and we're riding across it for free, but people won't let us use it.
Yeah, and that's their choice as the owner.
Because they think they can be sued.
Yeah. I mean, if that's their perception, and they're right, I mean, they can be sued. Whether or not the suit's going to go anywhere, that's a choice. If we did have the equine protection law in place, that probably wouldn't be such an issue, but unfortunately in New York,
One of only 4 states that don't have,
is it 4?
there's only 4 states that don't.
Oh, there's only 4 that don't?
There you go. I knew it was ticking up, but I don't follow it that close.
We've got a piece of land that, with a neighbor that is leased, and there's there's no actual contract written through there, but there's the assumption that they can use a trailer whenever they desire to use that.
A trailer, you said?
Yeah, one of my trailers they can use whenever they want to use
Okay.
it while use their land. Where does something like that fall under? Now, it's not really a cash or money being traded by hand, but there is an agreement there. Where does that put me in a situation where if they're using my trailer and I'm using their land, it's not a...
I would say, if I was the plaintiff, that there is compensation by virtue of you using their property and they're using your property. There's a mutual compensation there by the use. Could be worth money. It's what we call consideration. Whereas it's different if you're just letting someone use your land and not getting anything in return. As a defendant, obviously, I would say, well, there's no written agreement, no money changing hands. No agreement here, but you do have that consideration going back and forth. It's a thing of value. Also with the trailer, is this something that's being used on the road or just?
Yes, it's a on-road trailer.
You may have insurance coverage issues there. I don't know, if the trailer's involved in an auto accident or something. I don't know who would be on the hook for that insurance-wise, but
Okay.
something you might want to just discuss with your insurance agent. Make sure you have coverage for both when the trailer is unhooked from the vehicle, as well as when the trailer is hooked to your vehicle, and when the trailer is hooked to somebody else's vehicle. Those can be three different things. And then make sure that the trailer is also, the contents are insured. I'm not 100% sure, but I believe the contents are usually separate than the trailer itself.
Even with inherent risk, if New York had it, a lawsuit could still be brought, is that correct?
It could be, and probably would be in the early days of the law being in effect, but I think that would taper off pretty quickly.
And as far as like this lady was saying about riding across somebody's property, even though maybe the law lawsuit wouldn't be successful, they still could be sued, so now they have out-of-pocket costs or legal fees.
Sure.
So, I can
Sure,
obviously
and
understand why.
aggravation, and, yeah. Yeah, absolutely, I mean, even if you do have insurance, you're still gonna have aggravation, panic, distress, and your deductible, which could be, any amount.
We sometimes use the trailer of a neighbor, we do pay for it, it's a nominal fee. We know the trailer is insured, we know that we have insurance, or what kind of scary stuff are we into with that?
I don't think any unusual scary stuff, other than just making sure with your insurance company that your insurance will cover that trailer, and that their insurance would cover the trailer. At the same time, I don't know if your auto insurance would cover the trailer or not. It would depend on your policy. Usually you need a separate policy for the trailer, especially for the contents, but
In New York, the trailer was covered for the vehicle's towing.
Depends whether it's a personal policy or commercial policy.
yeah, I believe only the trailer is covered, not the contents, and maybe not the liability. Kevin, would that be personal or commercial? I don't.
On a personal policy, the liability would follow the towing vehicle. On a commercial policy, the trailer would have its own liability. And if either one of them, there's no physical damage unless that's on the policy.
Insurance, when you get another trailer, is not the trailers. But I don't think negligence-wise, you're gonna have, your coverage for your negligence if you drive the truck into somebody else. Obviously, your own auto liability policies. Mostly, I generally am not concerned with the damage to the equipment of the vehicle or the property. I'm concerned with the damage to the person, because that's where the money is. You have a special protection under the general obligations law for that free use of the land. Ordinary negligence is going to be exempted for the landowner. However, liability can still attach for willful or malicious conduct. If you have a spring trap or something on your property to ward away trespassers, and that hurts somebody, obviously you're going to be liable for that. I hope nobody's putting spring traps in their property, but